afternoon. My name is Kristen Simpsen, and I'm an attorney at McAfee Taft. I've been doing employment defense for about 15 years. And what I want to talk to you about today is some case examples related to residents and also a little bit of background about why this is important from a GME standpoint. And hopefully this is all, first part of my presentation is stuff you already know, and it's just a reminder. So the ACGME has issued mandates and guidance on disabilities. And this is a relatively recent requirement that makes it really important that everybody in this room knows what they need to do when an employee has a disability, how things need to proceed. There are barriers to residents having GME due to unclear policies and processes. If they have to force disclosure of their disability, their supervisor. That's why these policies are important, that there's other mechanisms and ways for the residents to be able to seek an accommodation. Because in a perfect world, if there is a resident that has disability or an issue, they would feel comfortable coming to you all in advance, and then you wouldn't necessarily have to engage in the fitness screening process. I recognize that that's not a reality that is always going to happen, but by having these processes in place, hopefully some of these other issues will be avoided in the future. And this is a slide that came from ACGME, and I'm not going to read through it because you guys can read just as well as me. I'm going to breeze through this pretty quickly to get to the case discussion. There's a recent JAMA article about barriers to disclosure of disability and requests for accommodation among first-year resident physicians. This was a survey of 1,486 residents. Of those residents, 173 of the surveyed residents indicated that they had at least one disability. Of those 173, over half said that they needed an accommodation, but they didn't feel comfortable making the request, and that therefore they just tried to soldier on, not move forward. Whenever residents did request an accommodation, most of them did receive them. The most frequently reported reason for not requesting an accommodation was fear of stigma or bias, a lack of clear institutional process for requesting accommodations, and then lack of documentation. Where the recent studies highlight the critical nature of program access, defined as access to accommodations or not needing accommodations due to an environment where access needs are already met, the well-being and performance of medical training disabilities. So if there is program access, if there is the ability for residents to know what they need to do to get a disability accommodation, your residents are going to be performing better. And if your residents are performing better, then there's going to be less medical errors, there's going to be better well-being, higher academic success of those residents. So that's why it's so important that your residents know what they need to do with seeking an accommodation and what you all need to do when you receive a request. So, and again, I'm going to go through this pretty quickly because Jim covered most of this already, but I just want to stress the importance that when an employer notices or becomes aware of a disability, that triggers the interactive process. And a resident does not need to use any special or type of language. They don't need to say, I have a disability and I'm requesting an accommodation under the Americans with Disabilities Act. That's not what it's going to look like. That's not what people are going to say. They're going to say, I have had some depression and I'm not sleeping. Can I take a break from my shift? Or can I get off early? That request right there is enough. But you want to notice that the interactive accommodation needs to begin, that you need to get more information about the resident's health conditions, about whether an accommodation needs to happen, or maybe there isn't a health condition and they just were saying that. But you can't just brush it off. You can't just say, oh, everybody's tired, all residents are tired, all residents need a break. You can't do that. The requests don't need to be in writing. It's enough to have a verbal conversation. So again, once you are aware of something, that puts the employer on notice, which would be whichever is your hospital. Also, a request for an accommodation can come once you've been provided with medical information. If a resident gives you medical information, you need to partner with the Human Resources Department at your facility to make sure that that is handled appropriately. You can't look at it and say, oh, I don't know what to do with this. There's not enough information here, so I'm just going to ignore it. That can't do that. You have to follow through, make sure that the right people are involved, the proper information can be had to engage in that interactive process that Jim talked about. That being said, you're not expected to be a mind reader. If somebody just says, I need to make a change, and they don't offer any explanation for what the underlying change is, they don't say that it's because of a medical problem, they don't say that there's a reason other than, that's just what they're desiring to do, that is not enough to be treated as an accommodation request. This case in particular, there was a school teacher that sent an email that said, I need paperwork, and what do I need to do to schools? Didn't mention that he had any sort of mental problems, didn't mention that there was a health reason behind the request, and the court held that that was not sufficient to be treated as an accommodation request. I have two cases that I want to talk to you about, both of which the court ultimately found the hospital or the program did not engage in good faith interactive process, and that there was a sufficient claim to take to trial. Surprisingly, we did a lot of research on this. Most cases, for good or bad, good for you guys, most of the time the hospitals were found to have properly acted and engaged in their interactive process. I'm not here to talk about those cases today because they're not as helpful, I think, for learning purposes. But do be aware that oftentimes when residents do bring cases for failure to engage in the interactive process, more likely than not, the hospital is ultimately found to be successful. But where there are some cases, and I'm going to go through a couple where the hospital or the program acted in a way that led to liability ultimately. So the first case is called Lawn versus Board of Regents of the University of Oregon, University System of Georgia. The plaintiff was a resident in Advanced Education Oral and Maxillofacial Surgery Residency Program. The program director receives 26 different communications about plaintiff's behavior from November 1st, 2012 to June 23rd, 2015. I'm just going to say as an aside, if you're receiving that many communications about somebody's behavior, you should act about it sooner than this entity did. It's unclear from 2012 to the end of 2014 if any of these complaints resulted in any verbal counseling to the plaintiff. However, in 2015, he was charged with a code of conduct violation. In this case, he participated in a surgical case with another department without the proper clearance. He was ultimately found guilty as charged and was placed on academic probation for the rest of his residency program. While the hearing for the code of conduct violation was pending, plaintiff's co-resident complained that plaintiff was aggressive, that plaintiff repeatedly called her a bitch and stated, if I find out anyone is backstabbing me again, I'm not afraid to go to jail. Plaintiff was placed on 2 weeks of administrative leave as a result of this behavior. However, after the administrative leave, the second code of conduct violation was filed against plaintiff. Ultimately, the second code of conduct violation was not substantiated. However, the committee noted that there were a number of individuals who had expressed concern about plaintiff, and that there were speculative reports that several individuals were fearful that the plaintiff could experience a personal breakdown in rational thought and proceed to violence. There was a delay again, but ultimately, the hospital decided that the plaintiff needed to be placed on an administrative leave until he completed a fitness for duty evaluation. After the evaluation, the evaluator determined that plaintiff was unfit for duty and further treatment was recommended. Over the next several months, he completed follow-up treatment. Following treatment, the center issued a treatment report that stated that as long as plaintiff complied with certain recommendations, he was fit to return to duty. The treatment report was provided to a program contact at the university. The recommendations that were in the treatment report recommended that plaintiff's initial contact with other residents, other supervising faculty were arranged through the program contact, that he had advance notice of any meetings that were going to be held. He was required to participate in therapy and needed scheduling adjustments in order to participate with therapy, and he was regularly supposed to meet with a workplace monitor. These were relatively minor adjustments. However, university didn't implement them. Ultimately, plaintiff continued to have problems. He was ultimately terminated when he was missing from clinic and failed to return a page. Instead of returning a page, he went and got in a verbal altercation with the program director and dredged up all of these past historical issues. Once he was terminated, he filed a lawsuit alleging disability discrimination under the Americans with Disabilities Act and the Rehabilitation Act. He brought both a disparate impact claim, which means he was discriminated against because of his disability, and he also brought a failure to accommodate claim. The court looked at all the facts on summary judgment and said, nope, there's not a disability discrimination claim here. You haven't proven that. But the court denied summary judgment on the failure to accommodate claim. And what that means, for those of you who haven't been involved in lawsuits before, is there's summary judgment stage is when both parties tell their story to the court and say that there's no facts here that would prevent judgment from being entered in favor of the defendant. And so the court said, yeah, that's true on the disability discrimination claim. But the court said, hold up, there are big fact questions about this failure to accommodate claim. I can't decide it. It has to go to a jury. And so the court looked at the various accommodation requests that the plaintiff had made and made certain rulings. One of plaintiff's alleged requests that he said he had made was for a supported and structured environment. The court held that this accommodation request was not specific because it didn't identify specific stressors. That broad request for supported and structured environment just didn't provide the institution enough information to be able to decide, is this a reasonable accommodation? Is it not? What can we do? How do we even, what does that even mean? It's not specific enough. It doesn't identify what he's having issues with. So the court found that was not a reasonable request that needed to be discussed further. There was also, after plaintiff was terminated, he tried to say, hey, don't terminate me. Let's go to mediation instead. That needs to be a reasonable accommodation for my disability because, we need to talk this through. You need to give me another chance. And the court said, no, there is no obligation for an institution to change its disciplinary processes as an accommodation to somebody. That's not something that's on the table. That's not something that's considered reasonable. However, the court held that the conditions contained in the treatment report, which were setting up the meetings with the program contact, going to therapy, having schedule modifications, those sorts of things were specifically identified and really in the grand scheme of things, probably not an undue hardship. Therefore, they should have been considered, they should have engaged in the interactive process. Instead, the hospital got the treatment report, kind of put it in a drawer, put the guy back to work. That is a huge, huge problem. And so the interactive process broke down. The hospital said, not our fault. He gave us the treatment report, but he didn't ever specifically ask for the accommodations. And the court said, well, he said that he needed to come back to work, and these were the things he needed to come back to work. So he made an accommodation request to him. And so this case went on to trial, and ultimately there was liability for the university system on this failure to accommodate claim. I have another case that I'm going to talk about really quickly, and then I'm going to kind of talk about problems with what happened and what you should learn from these cases. Next case is Thing versus Vanderbilt University Medical Center. In this case, the plaintiff was an ophthalmology resident. He had kind of a host of health problems. He has fatigue, trouble breathing, trouble concentrating. He had vestibular stenosis. He had surgery. After his surgery, his symptoms didn't improve. He alleges he requested schedule accommodations in December of 2014, which were denied. After his surgery, he met with the program chair and the director of resident education. At this meeting, plaintiff was referred to the university's EAP due to deficits in his knowledge, work ethic, and sense of responsibility. There's a disconnect right here because plaintiff thought he was getting sent to the EAP to help accommodate his disabilities following the surgery. The EAP provider informed him that the hospital had told him the purpose of the referral was to address performance issues. So there's a lack of communication that was occurring in this case. And anytime you have a lack of communication, that's going to be problematic. Later on, while this process was still occurring, he was diagnosed with hypothyroidism. He requested an extra accommodation of wearing extra layers of surgical attire to prevent his body against shivering, but the request was denied because the extra layer of clothing compromised the sterile field in the operating room. He was later placed on probation and then suspended due to an alleged patient interaction that there were some concerns about it. Following his suspension, he talked to the senior associate dean for GME about his health issues. He said, these health issues are causing some of my performance problems. I think I need some help. The next day, the dean responded and said, if he needed an accommodation to the residency program, he should contact the Equal Opportunity Affirmative Action Disability Services Office. But then he also upheld the suspension, extended his probation, revoked his promotion, or did not promote him to PGY3. The senior associate dean did not take any other additional steps to engage in the interactive process once he heard about the health issues. He didn't contact the office himself. He didn't contact any human resources. He just said, oh, if you have a health issue, you need to go talk to these other people. About a month later, plaintiff incorrectly administered an injection to a patient, and he was later placed on a second suspension. He never returned to work after the second suspension. After he was suspended, he did contact the EAD office through his attorney to request a reasonable accommodation. At this point, he requested certain schedule accommodations to deal with his health conditions, and the program denied the request on the grounds that the plaintiff was suspended and not working. Ultimately, the program made the decision to move the corrective action to immediate dismissal. After this, the plaintiff applied for a new residency at New York Medical Center. As part of the hiring process, Vanderbilt sent information about which rotations plaintiff had completed, his disciplinary history, and the result of the 2015 evaluations, which he had received a low score. Vanderbilt did not share that the plaintiff had requested an accommodation or that he had health issues. Based on the information provided, New York Medical Center withdrew its offer. Plaintiff filed a lawsuit alleging that Vanderbilt failed to accommodate his disabilities, and ultimately the court denied Vanderbilt's motion for summary judgment. The biggest issue in denying this was that there was a fact question about when plaintiff first brought his need for an accommodation to the attention of his supervisors. Plaintiff alleges that that occurred in December of 2014. The hospital was saying it didn't occur until much later. But the court said that the employee's complaint of being tired and fatigued in conjunction with an employee's request for breaks when he had long shifts could be sufficient to put the employer on notice of the need for an accommodation. So I think that's an important thing to note. And I know that that may be at odds with the reality of what the resident program is. They are working long hours, and people are going to be fatigued when they're working long hours. But this just highlights the importance of really listening to the complaints that residents are making so that you can take appropriate action to, engage in the interactive process as necessary. Ultimately, the court also held that there was a fact question about whether Vanderbilt properly participated in the interactive process. The court identified specific items as evidence that a reasonable juror could find that Vanderbilt did not adequately work with the plaintiff in the interactive process. The first thing was that the program chair did not entertain plaintiff's request for a modified schedule on his return to work following surgery. It was not something that was ever discussed. The program director just said, no, you've requested this, but we're not going to grant that. That's a big problem. At no time did the program chair, even though he was aware of the plaintiff's health conditions and aware that there were potential accommodations needed, he never referred the plaintiff to the EAD at any time. The program chair actually said that he didn't even know that there was an EAD reasonable accommodation process, which is a huge lack of training and knowledge that Vanderbilt had to deal with. The court also found that there was an issue with the fact that the dean's referral of the plaintiff to the EAD was done conditionally and not without reservation. It was done in the context of a disciplinary meeting, and that the plaintiff had raised this issue prior to the discipline taking place. And so the court noted that failing to discuss a reasonable accommodation in a meeting in which the employee takes an adverse action against an injured employee may demonstrate a lack of good faith in engaging in the interactive process. And finally, the court noted that the actual referral to the EAD came many months after the initial request was made. So what do these cases tell you? What should we learn from these cases? The first and most important thing is that you have to respond promptly to any request for a reasonable accommodation. Delays can harm you. It is better to err on the side of caution and say, hey, you have brought these concerns to me. You're having these performance issues. Is there a medical issue that you feel like you need a reasonable accommodation for? Before you have that conversation, obviously you should talk with human resources, make sure that all of your ducks are in a row about it, but there's no harm in having that conversation. The harm is you having knowledge, not acting on it, and then things snowballing out of control down the line. You need to remember that accommodation requests do not need to take any certain form. It can be as simple as identifying health condition in passing and identifying an issue with performing the job. That is enough. An employee doesn't have to say, I need an accommodation. They don't have to say those specific words. And if you're waiting to hear those words, it's going to be too long. You need to be proactive about this. And that goes into the next point that while residents do need to specifically make the need for an accommodation known, if the program hospital or the hospital comes in possession of information indicating that an accommodation is necessary, it's imperative that the interactive process be implemented. In both Lon and Singh, there were lots of red flags. Lon, there were 26 complaints about his behavior over a 3-year period, and nothing was done. I mean, they just let it go. And I know a lot of times, you guys want to, it's an education process, and there's obviously a learning curve, but you can't sweep things under the rug and hope that they're going to get better, because that's not going to put the program in a good position. It's not going to put the employer in a good position. And frankly, it's not going to be good for the resident either, because by taking earlier proactive steps and managing these sorts of things, it's going to be better for the resident. Maybe they can turn things around before things get dire. It's going to be better for the program because you're engaging in the interactive process and performing your obligations under the ADA and the Rehabilitation Act. The next thing that is important to learn from Lon and Singh is that if there is a breakdown in the interactive process, make sure that you document it and make sure that the program or hospital has sent the last communication concerning the interactive process. If we look at Singh, the plaintiff provided that treatment report that had specific recommendations in it, and the hospital did nothing. That is a big problem. So if you get something that looks like there is a modification to a schedule request, if it looks like, other modifications maybe need to be made, that somebody needs to sit down for 15 minutes out of every 4-hour shift, whatever it may be, make sure that you have documentation about, yes, we're granting these accommodations, or if you can't grant the accommodations, make sure that's in writing too. What we don't want out there is just a request and no response in writing, because that is where it's hard to defend a case after the fact. So if there is a request in place, you need to make sure that you're working with the appropriate offices, that the response to the request is put in writing and given to the employee, and that there is this is the information we have from you. These are what your accommodations are. If you disagree, please contact us immediately, rather than just even having a verbal discussion. We want to have a paper trail that documents everything from the initial request, fitness for duty, any accommodations that need to be made, and if there were any accommodations that couldn't be granted, we want that all to be in writing. And then also, you need to know that the people below you that are having interactions with residents, that they have knowledge about what's on the lookout for. Because we had here, there was an individual who didn't even know that there was any reasonable accommodation form available. And so you are only as strong as your weakest link. And if you have people who are supervising residents, who are interacting with residents, and they don't know what their obligations are, they don't know what puts them on notice as superior to these residents about, when the interactive process should be engaged, when a fitness for duty might need to take place, there's potential liability there. This is a bit of a repeat, but it's really about meaningful communication with the employee about health issues. Don't avoid or hesitate. Don't think that's not my place to ask, that's not my place to get involved. If you are aware of a health issue that is causing performance issues for a resident, that is when you need to talk to human resources and figure out the best way to handle it. Maybe it's a minor thing and there isn't anything that needs to be done, but maybe it is fitness for duty. Maybe it's not a fitness for duty, maybe it's just a reasonable accommodation request that needs to go through the employee's position. But at the end of the day, it's on the employer, not the employee, to be proactive when investigating disability and accommodation circumstances. One other thing that I think is important, because you all are all doctors, is that it's not your role to diagnose the employee. It's not your role to second guess the employee's healthcare provider. If you doubt the validity of the employee's limitations, if you question, if you've been involved in the interactive process and you question the first opinion that's been given, you need to work with human resources in the program to get that third opinion that Jim is talking about. But it is not your role at any point to diagnose the employee or, engage in the process that way. That's not your role. Your role is to work with the employee to make sure that they're getting the accommodations that they need for the health condition, but not diagnose or treat. And then the final thing that's important to learn from Lon and Singh is that you need to be careful if you are asked to provide information about dismissed residents. Make sure that you're providing complete information. There was some liability for Vanderbilt and Singh because they provided a less than clear picture about what had happened to him. They dismissed him, and said he performed poorly on his June evaluations, but they didn't say all of these other things are happening at the same time. And obviously that's a fine line to walk because you don't want to provide confidential information that should not necessarily be provided. But that's where if you get this sort of request, it's important to talk with your human resources department, talk with your legal department to make sure that you're responding appropriately in a way that minimizes risk for your program. That's all that I have, unless anybody has questions.
A lot of information, so we're going to put it up to questions. And I think we've got a question right here from Dr. Alex.
Thank you for your presentation. Thanks for your presentation. At family medicine had an unfortunate circumstance several years ago where we had a resident that we had asked for a fitness for the evaluation. That was the evaluation. That was a problem for some that we removed this point from their duties. With all of the different hospitals that employ residents within our consortium, they all have different HR policies as it pertains to EAP. How does the consortium manage the differences and what liability does the consortium have if there is a lawsuit placed by that terminated resident?
So it will depend on what role the consortium plays in making those decisions. There's always the risk of an employer between the hospital and the program. And so I know the case that you're talking about, they worked on it. I know there was a lot of moving parts with that case. And so really the best thing that you can do is if you have residents who are at different employers, even though it's hard, you need to familiarize yourself with at least who the HR contact is so that you approach them and you work side by side together. And that's the best way to deal with these circumstances. We have all of the different employers for the different residents. If you are the ones making this decision, there's certainly a possibility for joint employment. In the case that you're talking about, there was an allegation of joint employment between OSU Medical Center, Mercy, as at the time was they partnered with OSU Medical Center, and then the Health Sciences Center had been sued also. And it wasn't enough to say that the Health Sciences Center wasn't the employer. There were additional claims brought against the Health Sciences Center and an allegation of joint employment. And so there's not really a great way to avoid those sorts of claims because you are making it. You're the ones who are saying, we've evaluated this person, we've looked at their performance, we think they need a fitness for duty. And that goes broader probably than we're trying to talk about today. But the best advice I can give you with all of those different residents is, maybe Dr. Song can speak to this further later or now, that just partner with the HR people at your individual institution to make sure you're following those policies. Talk to the program director to make sure that you're following the policies that OSU CHS has put in place. And that's your best way to get your liability.
So to caveat all that, a lot of times you see each of the policies contact your contact the DIO. Because I think that there's, whether it's overreach or not overreach, there's always going to be some implication. The sponsor institution has a responsibility for governance of all the programs. And so that's why I think what Kristen is saying is correct, is we really have to communicate, don't handle things completely in a vacuum and independently. And I know for some of the people sitting in this room, sometimes there's this really blurred line between who's really in charge of this program. Is the program director, or is it the hospital that actually employs the resident? And I think that there has to be a good relationship between the two. One of the biggest things that I get frustrated about is that HR disciplines the resident without notifying the program. That's a problem from an academic standpoint. And those things should probably be addressed prior to any type of disciplinary action being conducted with a trainee, because the training ends up serving as kind of a protected population. So it becomes really important, no way, 100%, no way to avoid everything program that there's occasions like that. Communication with the sponsor institutions to be early. And I know most of the program directors now let you know what's going on, letter of concern, as opposed to a reasonable action. I can really encourage that because there are areas that we may be able to help with or we may not help. And a lot of times I give you guys 25 different things that, hey, try this with resident, try this with resident, try this with resident. I know it's exhaustive. It's important. But what you're saying is, have we responded to the concern that's been addressed by the resident? Yes, we've done this, we've done this, we've done this, we've done this. And probably earlier identification, early involvement of HR is going to be very, very important. Other questions?
I'm Aaron, like the anesthesia program director. It's just a basic policy and process question. So, for instance, if we had someone who might have suspected substance abuse disorder, I don't know, what would be the appropriate order that we contact them and start rolling out the process?
You know, from an OSU Medical Center standpoint, please make contact if it's after hours or house supervisors. That was a little bit what I talked about, is that first step is going to be to rule out the obvious. And so we're going to start there. But then our HR department, because she talks about HR disciplining the resident, but it's never going to be us, right? We're always going to work hand in hand real closely with you. But reach out if it's after hours, house supervisors. If it's during hours, reach out to employee health, call me directly. We're going to start with that process. We're going to look at it as an employee. What do we do as an employee? And that happens fairly routinely. Not it happens often enough we know what to do. And then we're going to partner with you as the program director, with Dr. Song, and make sure that you know what steps we're taking along the way. We typically take the approach that you always suspend a person who is suspected of substance abuse. We suspend immediately because you can always take a time out and back up and reinstate later, those sorts of things. We don't ever put anybody in a vehicle. We arrange for a ride home. They get a friend to bring them home. We get an Uber. We do something. We're never going to stick somebody in a car that we think might be impaired. Now here, take your keys and go drive. And again, if it's after hours, house supervisor, if it's during hours, employee health, myself. And I think probably most every HR department is going to operate real similarly to that. Thanks. And, that also makes me think, Kristen did a great job. Dr. McClanahan and I were sort of talking about when you suspect something, and not necessarily even substance abuse, but when you suspect something that's more behavioral in nature, more mental health. And Kristen did a great job of bringing up these other situations where you don't necessarily suspect something, but something sort of presents itself to you. And so I'm really glad you covered that. It's both sides of that coin.
I want to talk about something that they both emphasized. I know I've had this issue with a program just recently. So I used the radiology example, but we had a resident that requested to see 4 patients throughout their entire residency during their office. And it was a family medicine resident. And you've got to understand it's an unreasonable accommodation, because how do we successfully evaluate a trainee that can only see 4 residents, 4 patients in an 8-hour day? And so there is that interactive dialogue that we talk about. It's back and forth. This is reasonable. This is unreasonable. We can't successfully evaluate you to be practicing autonomously if you can only see this. So understand that sometimes the residents may ask for, a litany of things, but I think it's really important for you guys to work with your respective HR departments. Use us as counsel, as a resource. A lot of times we'll defer to either legal counsel or HR because some things are beyond our purview, but we can work with you to make those things happen. Not everything, I think, has to go through this fitness for duty evaluation. We had a great example here with the Irrigation resident that needed accommodation for physical impairment that didn't go through fitness for duty evaluation. It was granted, I would say, in days once the case was actually presented to us. So not everything requires this interactive piece. It makes sense.
The other thing to remember is you don't have to grant the requested accommodation. An employee can have a preferred accommodation, and that isn't what has to be granted. If there just has to be something given that does not cause an undue hardship that allows the employee or the resident to complete the essential functions of the job. And it may be something that the employee doesn't necessarily want, but still allows them to do it.
We had a resident in the past that we suspected something was triggering him, but he was always, if it was a substance abuse, he was always smart enough to not come to work hungover or, there was nothing that there was not enough proof for us to say, like, we suspect he was here, but we suspect maybe he could have been outside of work, but not enough. In that case, what do you do? Because he would go MIA for a few days, we didn't realize he wasn't showing up or things like that. So it's, that itself is concern for substance abuse, but when he came to work, there was never any concern, never smelled anything, never any, concerns about his performance. In that case, what did you recommend?
Yeah, from an employer standpoint, I'd always say, remember, all of your other policies still apply. So if you have attendance expectations, if you have behavior expectations, if you have dress code expectations, whatever they may be, those don't go out the window just because if you test him, he's probably not going to show positive for either drugs or alcohol. And also remember that if he's taking prescribed opioids or Adderall, those sorts of things, and he's taking them outside of their intended purpose, that's going to come back as a negative drug screen because there's a valid prescription in place. And as the employer, there's not too much that we can do about that. Then we have to start talking about, well, what are the other behaviors that we're experiencing? Well, you were late on this. You didn't show up here. You were didn't announce that you were leaving. Your documentation was inappropriate, et cetera, et cetera. And if it ends up being impairment that we can't show otherwise, then we need to have 2 or 3 witnesses and talk about what it is that we're experiencing, what we're seeing, and then probably have to send for an outside independent fitness for duty where maybe he would have a more frank conversation with a Dr. McClellan type of situation. Those other things just don't go out the window just because they're negative drug screen.
Okay, and I definitely understand that. It's just like, can we request this fitness for duty? Don't really have any.
You did have objective evidence. You said that he wasn't showing up as planned. He wasn't available when you thought he should be available. He was missing time. That's very objective. Absolutely, we could request something. Again, we want to partner with the program. If it's our employee, we want to partner with you and talk through that a little bit. But as you present it, yeah, I think that would be one where we would want to move forward. And we wouldn't want to just take the employee's physician's insight. We would want that certified specialist psychiatrist to actually do the evaluation. Anecdotally, we had a situation where an individual came back to work with a full release, returned to work after a known behavioral event. And like the second day on the job, the individual took all the belongings off their desk and taped them to their door. And so why did you do that? What are you talking about? You just taped everything to your door. Why didn't you have done that? He decided it was time to do a second opinion fitness for duty. And that was a great situation. I'm sure that Dr. McClellan is the same way. That doctor got on the phone with the treating physician, the employee's physician, and they talked through medication changes. Took the employee back off for a couple of weeks, did some changed medications, and that was years and years and years ago, and that individual is still happily employed where they're at. So sometimes it's just that coordinated effort, even outside of interactive dialogue, that coordinated treatment effort.
No specific items included in a fitness for duty. I mean, you're not just going to put it in and say, hey, is this employee having substance abuse issues? You say employee has been missing work, employee has done XYZ behaviors. Please evaluate for fitness for duty concerns in light of these behaviors and in light of the job description.
Yes. and I know the case that you're talking about very specifically, and it's one that we actually put, I would say, a lot of time and investment to this resident to independently seek counseling, et cetera, hours and hours of time spent there. The question is, really, should we have mandated an HR visit? And, you know, looking back, hindsight is 2020, possibly should have mandated it to see if they would willingly do it. You know, we were trying to request accommodations for the resident on their behalf. They're only no.
So here's the thing, if you try and they shut you down, you document it and then you discipline. Like you don't, just because they refuse to do it doesn't mean that's the end of it. You can either force the issue with the fitness for duty, or you can say if you refuse to engage in the interactive process, then the next step is discipline.
That's what we ended up doing, but like I said, hindsight's probably 2020, resident performed incredibly well in the clinical realm when they were there. Very difficult situation because we were trying to give the residents so many opportunities to self-correct. But probably should have come involved to see if there's a way that we could mandate it. Any other questions? Very good discussion, I think. Are there any questions from Zoom that I cannot see? Okay, well, then that is going to close the faculty development today.